Hello, good afternoon, and we welcome today in this group E two teams for the Inter-University Law Debate Tournament, day 3 of the group phase. We have the United Arab Emirates University debate team, and we have as well the University of Malta debate team. So these two teams will be debating on a topic they received a week ago, and of course we'll talk about it a bit later in this session. First, of course, we want to hear who are the debaters for this match today. So I give the floor first to Miss Veidan Salem Alawi Al-Nuaimi. Welcome.
Hi everyone, good afternoon, good evening. My name is Wujdan Adel Naimi. I wish everyone the best today and the last match of the phase 1.
Thank you and welcome. We have as well in Malta Miss Karaborg Aquilina.
Hello everyone, it's a pleasure to be debating with you today. Wishing you the best of luck and looking forward to the next phase of the competition.
Thank you very much and welcome. We have as well in Al Ain, Al Anoud Dastagir. Welcome.
Hello everyone, good afternoon. I wish everyone the best and I wish everyone the best of luck, and I'm really excited for this debate. Thank you.
Thank you very much and welcome. And we have as well in Malta Mr. Michael Gatt. Welcome.
Hi everyone, looking forward to a very fruitful debate. Good luck to the opposition as well.
Thank you very much. And third member for the team at United Arab Emirates University, Afra Salem Abdul Rahman Al Manair.
Hello everyone, good afternoon. I wish everyone best of luck for today's debate, and thank you.
Thank you very much. And greetings as well to one coach connecting in this moment, Professor Karam Abul Zalm.
Yeah, Karim Abul Azm. Good afternoon. Hello, everyone. I'm so happy to be with you today, and I'm wishing all the best for the two teams.
Thank you very much, and we send greetings to your colleague, Professor Mohamed Al-Shamsi, and as well on the side of the coach for Malta, Dr. Antoine Grima and Professor Omar Gresh, and Dean Mifsud, who is watching maybe on YouTube. So as you can see, for this match, there are two possibilities, to be in favor or to be against the motion. The team in favor will be starting the match with the first introduction. For this match, the team will be against the motion will be the University of Malta. As a consequence, the team in favor will be the United Arab Emirates University, and United Arab Emirates University will be starting the match with the first introduction. So now you will have 5 minutes to review your notes, and then we start the match with the team from in Al Ain.
Thank you, everyone. This marks the end of your preparation period for the debate. Before hearing the opening statements, just a short reminder, you will get visual cues, yellow card for 30 seconds left, and red card for when your speaking time is up. And thus, without further ado, United Arab Emirates University team, you have 4 minutes for your in-favor opener.
Am I visible and audible?
Yes.
Okay, I will start in 3, 2, 1. Distinguished judges, respected members of the opposing team, good afternoon. We are the team of the United Arab Emirates University, and we stand in favor of the motion that international commodity markets must require traceability of supply chain sourcing to prevent human rights violations. This debate concerns accountability in a global economy. Commodities such as minerals, oil, and agricultural goods move through complex supply chains, yet the conditions of their production often remain invisible. When supply chains are opaque, exploitation is not incidental but systemic. The issue before us is whether international law must require transparency to make human rights obligations enforceable. Our case rests on two arguments. Firstly, international law requires due diligence and traceability. International law has already evolved towards requiring supply chain responsibility. The United Nations Guiding Principles on Business and Human Rights reflected established state obligations to protect against human rights abuse, and that businesses must exercise due diligence to identify, prevent, and mitigate harm. Due diligence is not possible without traceability. A company cannot assess risk if it does not know where its materials originate. Similarly, the OECD due diligence for responsible supply chains requires companies to map their supply chains and identify risks of human rights violations, particularly in sectors such as minerals from conflict-affected areas. These standards are increasingly reflected in binding legal frameworks. The European Union's Corporate Sustainability Due Diligence Directive requires companies to identify and address human rights risks through supply chains. Modern slavery legislation in jurisdictions such as the UK and Australia requires disclosure of sourcing practices. These developments demonstrate a clear legal trend. Traceability is not a new burden, it is the legal bridge between obligation and enforcement. Making traceability mandatory aligns international commodity market with existing legal principles rather than introducing a new requirement. Secondly, without traceability, human rights protections are ineffective. Human rights depend on the ability to identify violations. Without traceability, accountability becomes impossible. Many of most serious violations occur at the earliest stages of productions. These include forced labor in fishing industries, child labor in cocoa production, and exploitation in mineral extraction, such as cobalt mining, where children work in hazardous conditions and are exposed to fatal risks. According to International Labour Organization, an estimated 1.6 million children are engaged in hazardous child labor globally, with many suffering severe injury or death. A system without traceability allows companies to benefit from low-cost production while avoiding responsibility. The absence of information creates plausible deniability. This undermines both domestic enforcement and international legal standards, as illustrated in the case of Nestle USA versus Doe, where claims of child labor in cocoa supply chains failed due to limits on holding companies accountable for foreign conduct. When sourcing is transparent, companies cannot claim ignorance, regulators can identify violations, and accountability becomes enforceable. Existing frameworks such as Kimberley Process for Conflict Diamonds and the EU Timber Regulation demonstrate that traceability is both feasible and effective. Requiring traceability does not restrict trade, but ensures that trade does not depend on exploitation, making human rights violations visible and therefore preventable. Thank you.
Thank you very much. This marks the end of the opening statement for the in favor position. For the against position, University of Malta, you have 4 minutes.
Am I audible and visible?
You are.
I will start in 3, 2, 1. Honourable judges, esteemed opponents, good afternoon. The motion proposes that international commodity markets must require mandatory traceability to prevent human rights abuses. At first glance, this seems intuitive. If we can trace where goods come from, surely we can stop abuse. But this motion makes a critical leap. from the existence of a problem to the assumption that traceability is the solution. We reject that leap. The opposition does not deny that human rights abuses exist in the global supply chains, nor do we deny the urgency of addressing them. Our case is that mandatory traceability is the wrong tool. It is legally unfounded, practically ineffective, and economically harmful to the very people it claims to protect. Our case rests on three contentions. First, mandatory traceability lacks a binding basis in international law. The affirmative builds its case on instruments such as the UN Guiding Principles, the OECD Guidelines, General Comment Number 24, but all of these share one critical feature, that they are non-binding. They are soft law recommendations or contested interpretations, not enforceable obligations. International law does not allow us to transform voluntary standards into compulsory global rules without state consent. To impose mandatory traceability as a universal requirement would therefore violate the foundational principle of state sovereignty. And the clearest evidence of this, states are still negotiating whether such obligations should exist at all. If there were already a legal duty to impose traceability, there would be no need for negotiation. The affirmative's legal framework is not a foundation, it is an aspiration. Second, traceability does not create accountability. At best, traceability gives us information, but information is not enforcement. The core problem in global supply chains is that we do not know where abuses occur. It is that no one can effectively act on that knowledge. Jurisdiction is fragmented. Courts are reluctant to hear transnational claims. In the Kiobel case, US Supreme Court barred extraterritorial human rights claims precisely because jurisdiction does not follow the supply chain. Even landmark cases that allow cross-border claims are rare exceptions under highly specific conditions. So we must ask a simple question. What happens after we trace the abuse? Who prosecutes it? Which court has jurisdiction? Which state enforces it? If there is no clear answer, then traceability produces documentation, not justice. It creates the appearance of accountability without its substance. Third, the evidence shows that traceability fails in practice and can cause harm. Let's be very clear. This isn't a theoretical debate. We have real-world evidence. In the Rana Plaza disaster, global brands already knew their supply chains. Audits had been conducted. Factories were identifiable. And yet, over 1,100 workers died. The problem was not lack of traceability. It was lack of enforcement. Similarly, in the cocoa industry, decades of traceability and certification have not eliminated child labor. Why? Because the root causes, poverty, economic dependency, remain unchanged. Traceability records the problem, it doesn't solve it. Worse still, mandatory traceability imposes heavy compliance costs. Large corporations can absorb them, small producers in developing countries cannot. The result is exclusion from global markets. We saw this with conflict minerals regulation. Companies simply stopped sourcing from affected regions altogether, devastating an artisanal mining sector that had supported an estimated 785,000 miners. This motion is built on a flawed assumption that more documentation equals more protection. But without enforcement, without legal grounding, and without economic realism, mandatory traceability becomes a system of paper compliance that fails to address the root causes of abuse. We urge you to reject the motion. Thank you.
Thank you. We'll now hear the first rebuttal for the in favor position. United Arab Emirates University, you have 2 minutes.
Am I visible and audible?
You are.
I'll start in 1, 2, 3. Honorable judges, the opposition raises the concern about sovereignty, trade burdens, legal caution, and enforcement gaps, and economic cost. But there is one central question they have to answer. How do you prevent abuse in a supply chain when you can't prove it exists? That is the heart of this debate, because oppositions may warn us about traceability is difficult, that international law is cautious, or that implementation will vary across states. But none of that changes the core reality that hidden sourcing protects abusers. If companies do not know where their commodities come from, then they can always claim that they do not know where forced labor happened, or where child labor occurred, or where exploitation entered the chain. That is when accountability collapses. Regulators cannot investigate effectively, victims cannot trace responsibility, and markets continue to benefit from the abuse. That is why traceability is important, not because it aids in the resolution of human rights violations, nor does it diminish the necessity for domestic enforcement, but because it eliminates plausible deniability. If companies cannot clearly trace where their goods come from, they cannot prevent exploitation before the harm is done. This is not only a worker protection case, it is a community one as well. In a Business and a Human Rights Resource Center review of allegations involving Swiss commodity traders, 60% concerned impacts on communities, including land rights abuses, displacement, violence, and violations of indigenous rights. When traceability is required, market actors begin to change their conduct because exploitation is no longer hidden from the world. So perfection is not the standard on this debate. The real choice is between limited transparency and complete opacity. And if the real goal is to protect human rights in a global commodity market, then opacity is the worst system. Thank you.
Thank you. University of Malta, you have 2 minutes for your first rebuttal.
Thank you. Am I audible and visible?
You are.
Okay, so to get into it, the affirmative's first and most intuitive claim is that traceability is necessary because abuses are hidden and visibility enables accountability. At face value, this sounds reasonable, but it rests on a very deeply flawed assumption that lack of information is the core problem. It is not. We already know where human rights abuses occur. We already know about the labor issues that occur. We know about forced labor in cotton, child labor in cocoa, unsafe factories and textiles. These are not hidden problems. They are well documented, they are widely reported, and they persist despite the visibility. There have been many cases mentioned already at this point. Some of them, my colleague mentioned, the Bangladeshi case of Rana Plaza collapse is a total evidence of this, that traceability existed, but failed to prevent the violations that occurred as well. The garment factory killed 1,100 workers whose origins were known, who still sought no justice as well. On another case that has been mentioned as well, Nestle failed because of jurisdictional issues, not because of traceability as well. Similarly, in the Kishel versus Royal Dutch Petroleum case, the Zambian UK case, there were limits of holding corporations liable for overseas HR abuse. Traceability does not solve jurisdiction here, but barriers did. Now, since we already know where these issues here, the issue that we have is not that we lack information. The issue is that nothing happens when we have it. Traceability gives you a map, but it does not give you a mechanism to act. It does not create jurisdiction, impose liability, or ensure enforcement, and that is the structural gap that the affirmative cannot solve. Once you trace the abuse, what happens next? Which court hears the case? Which state prosecutes? Which company is legally responsible across a multi-tier supply chain? If there is no clear answer, then traceability produces documentation without consequence. And that is very dangerous because it creates the illusion of accountability while allowing these abuses to continue. So the affirmative is not solving the problem. They are reframing as a data problem, and there is no enforcement intact. Thank you for the floor.
Thank you. For the second rebuttal in favor, United Arab Emirates University.
Okay, I'll start in 1, 2, 3. Opposition try to convince us by focusing on hard cases. They claim that supply chains are too complex, producers are too fragmented, poorer regions lack administrative capacity, and enforcement will never be perfect. However, they do not realize that the entire line of argument proves far less than they wanted to, because difficulty in implementation is not an argument against the rule itself. It is, in fact, the strongest argument for why this rule is needed. Let us be clear. No series of area of regulation works perfectly from day one. Labor law is evaded, tax law is manipulated, environmental rules are circumvented, and anti-corruption systems are abused. Yet no one concludes from that reality that we should simply abandon all regulations and allow invisibility to continue. The proper response to enforcement problem is better enforcement, better design, phased implementation, and targeted support, not surrender. We mentioned due diligence in our arguments and how the United Nations Guiding Principles on Business and Human Rights reflect established state obligations to protect human rights abuse, and that businesses must exercise due diligence to prevent, identify, and mitigate harm. Therefore, due diligence is impossible without traceability, and a company must know where its commodities originate to assess risk of abuse. And that is exactly how this motion should be understood. Requiring traceability does not mean pretending every state has the same resources or that every producer has the same capacity. It means setting a baseline principle that global markets should not profit from anonymous exploitation. From there, implementation can be proportionate. Transitional periods, sector-specific method, technical assistance, simplified compliance for smaller producers, and stronger oversight where risk is greatest. In other words, the existence of practical difficulty tells us that to improve our framework, not to reject transparency altogether. Thank you.
you. University of Malta for the second rebuttal.
I'm visible.
You are.
I will begin in 3, 2, 1. The proposition mentions the ILO. ILO conventions impose obligations on states, not on commodity markets. It's very important to keep that in mind. The enforcement mechanism for ILO conventions is the ILO supervisory system. The committee of experts, the conference committee, the representations and complaints procedures under the different articles of the ILO constitution. The ILO has never concluded that product level supply chain traceability is a required mechanism for convention enforcement. The ILO's own approach through programs such as the ILO IPEC child labor initiatives, they work through partnerships, capacity building, development, not through mandating that commodity markets document every transaction. So the affirmative is grafting a regulatory mechanism onto the ILO framework that the ILO itself has not endorsed as necessary. Also, the proposition mentions, once again, the UN guiding principles. These are soft law. The OHCHR's own interpretive guide mentions that they are not legally binding. The different resolutions were adopted on the express understanding that no new obligations would be created. The different guidelines, the recommendations, they are in treaties. The general comment as well is an interpretive statement by a treaty body that has been expressly contested by the UK, by the US, and by other states as well, precisely because it asserts extraterritorial obligations those states do not accept. So the affirmative's legal pyramid in total is built entirely on soft law and contested interpretation. So if the obligation already existed, there wouldn't be the need for 74 countries to negotiate a new binding treaty. The negotiation itself is the evidence that the binding norm does not yet exist. And so therefore it cannot be said that there's the mandatory requirement for traceability because it doesn't yet exist. And thank you for the floor.
Thank you very much. This marks the end of rebuttals. For the concluding statements, United Arab Emirates for the in favor position. 2 minutes.
Am I audible and visible?
You are.
I will start in 1, 2, 3. Honorable judges, at the close of this debate, the question before you is no longer abstract. It is simple, direct, and unavoidable. Can we truly protect human rights in the global markets while allowing supply chains to remain invisible? Our answer, grounded in law, logic, and reality, is no. We have shown that international law is already moving toward due diligence and accountability. But due diligence without traceability is an empty promise. It is a standard without a mechanism. Enforcement. Am I audible?
Yes.
Yes, you are. I have paused the timer. You have 1 minute and 25 seconds.
We have shown that international law is already moving toward due diligence and accountability, but due diligence without traceability is an empty promise. It is a standard without a mechanism, an obligation without enforcement. Traceability is what transforms principle into practice. We have also demonstrated that without transparency, the worst form of expoliation thrive in the shadows. Forced labor, child labor, and hazardous working conditions are not accidental. They are sustained by systems that allow actors to deny knowledge and evade responsibility. When sourcing is hidden, accountability is impossible. And the opposition, despite all their concerns about cost, complexity, and sovereignty, has not answered the central issue.
Your microphone cut off. You have 37 seconds and you were cut off at the have not addressed the central issue.
Okay. We are not asking for perfection. We are asking for visibility, because once supply chains are visible, responsibility becomes traceable, enforcement becomes possible, and behavior begins to change. This is not about restricting trade. It is about ensuring that global trade is not built on invisible suffering. It is about aligning markets with the fundamental principle that profit must come at the cost of human dignity. So the choice before you is clear: a system that hides abuse or a system that exposes it, a system that enables denial or a one that demands responsibility. For the protection of human rights and for a system where accountability is not optional but required. We strongly
Thank you. University of Malta, you have 2 minutes for your concluding statements.
Thank you. Am I audible and visible?
You are.
Yes, so I will start in 3, 2, 1. Honorable judges, this debate was never about whether human rights abuses exist. They do, and we demand very serious solutions. The question is whether mandatory traceability is one of them. We have shown that it is not. First, there is no binding legal basis for imposing traceability as a universal requirement. The affirmative relies on soft law and very contested interpretations, attempting to turn voluntary norms into compulsory obligations without state consent. This is not a small technical issue. It goes to the heart of how international law functions, whether obligations arise from consent, not assumption. Second, traceability does not solve the enforcement problem. It tells us where the harm occurs, but not who is responsible and who can act. Without jurisdiction and enforcement, there is no accountability. Without clear jurisdiction, without enforcement mechanisms, and without institutions willing to be able to act, tracing abuses simply tells us where harm occurs, not how to stop it. In other words, the affirmative gives us visibility without consequence, and visibility without consequence does not protect a single worker on the ground. Third, the empirical evidence is decisive. Traceability systems have failed to prevent major abuses from industrial disasters to child labor. And worse, they impose costs that exclude small producers, creating economic harm for the very communities this motion claims to protect. What the affirmative offers is not a solution that helps in reality. It looks compelling in theory, but it collapses in practice. It creates the illusion of action while leaving the underlying problems untouched: weak enforcement, poverty, and structural inequality. It allows for companies and states to say they are acting without requiring them to meaningfully change their behavior. Human rights protections requires real accountability, not just documentation. Mandatory traceability does not deliver that. For these very reasons, we strongly urge you to reject this motion. Thank you.
Thank you, everyone. Well done. This officially marks the end of your group phase. You can all now relax. You're no longer evaluated after this part. And really, congratulations on wrapping up your day 3 match and also concluding and wrapping up your group phase of the Hague Inter-University Law Debate Tournament. As always, the judges do have the time to review the match and submit the scoring cards. So once we evaluate them and confirm, we'll share them with you and of course announce the results. But already, as is the tradition, I would like to invite you to take the floor for the reflection on the topic, on the research. If you perhaps heard a familiar argument from the opponents, and how did you find the exchange today? Starting with the team of United Arab Emirates University, Ms. Weidang.
I would like to thank the other team for their performance today. It was amazing as usual. I think referring to the topic today, I was a bit neutral about it. I wasn't really interested in it because I've never heard about it. However, it was interesting to search more about it and learn more about the examples out there in the world, because it happens a lot and we hear about it in our regular days, but we're looking at it from the law perspective. So it's interesting. I think that's overall respect. Thank you.
Mr. Gatt of University of Malta, how was the exchange?
Firstly, I'd like to thank the opposing team for producing what was a very fruitful debate, I thought. It was very interesting taking, I think, the against perspective, especially in this debate, because it's very topical. It's very, maybe the pro stance is a bit more relatable for many in this as well. So it was quite interesting taking on these shoes and seeing the performance that they put up against us. So thank you very much for your participation.
Thank you. And Ms. Almanea?
I would like to thank everyone, and the topic was really interesting. But I was also with my friend colleague Wajdan. I am neutral with the topic. I like the previous ones, but it was really nice to research about the cases and everything. Thank you.
Thank you. And Ms. Aquilina?
Thank you to the team from the University of United Arab Emirates. It was a really fruitful discussion. I really enjoyed it. And as you've all mentioned, I just wanted to reiterate that it was a very interesting topic, topical, relevant, maybe not the initial sort of research area of interest that I would have in mind, but it still gave us the opportunity to learn more about things that are happening all across the world, more from a legal perspective as well, learning more about the cases and the jurisprudence. So hopefully the topics in the future will also enable us to go beyond maybe what's our initial areas of research and to continue learning and growing through this process. So thank you.
Thank you. And Ms. Sayed, how did you find the debate?
I found it really interesting and fun. And honestly, it was way better than I expected it to be, especially that, as everyone have mentioned, it is a topic that we have never heard of before. And it really gave me new perspective on it. And it's the first topic that I have felt that I'm actually neutral in it without having my own point of view on it, like before knowing the topic or before researching about it. So yeah, I have had a lot of fun and I wish everyone the best again. Thank you.
Thank you very much. And of course, as we have one of the coaches present, Mr. Abdulazam, would you like to share some words of encouragement for the teams?
Yeah, first of all, I would like to thank you, thank the foundation for the organization of this competition, and I would like to thank also the other team, University of Malta, for your debate performance, and of course my students. I want to thank them because they did a lot of effort, especially in this tough time, and we are, completely shifting to online teaching. So I would like to thank them, and I hope the best for all the teams.
Thank you very much, Professor. And it's been quite a journey for the students from the day 1 to the day 3. You have had many challenges from the debates in preparation all the way to execution. Of course, you have also the upcoming mid-edition networking event, and of course, then information about the next stage of the competition. Would there be anyone that has inspired you, encouraged you, or otherwise motivated you, be that from your opponents, your friends, family, coaches, that you would like to use this opportunity to give a shout out to? So first for the University of Malta.
So I'd like to use this opportunity to thank our mentors, Professor Ivan Mifsud, the Dean, Professor Omar Greg, Dr. Antoine Grima, Dr. Therese Comodini Kakia, everyone, Dr. Joe Bujeya. I'd also like to thank my colleague Michael as well for his constant teamwork, and Dr. Ioannis as well. And the Corax Foundation as well for their support and for the great opportunity. And I'd also like to thank the universities who we've debated against for also bringing their best game and always giving us what to think about and really producing some really intellectually rigorous debates. So thank you to all those people.
Thank you. And now to the team in Al Ain.
I as well will start by thanking the Corax Foundation, all of my mentors, Dr. Karim Abdelazem, Mohammed Shamsi, my teammates, everyone, and I would thank the other teams we have debated against. I think one thing I've learned from this debate tournament is that always strive for the best, never settle for the less, and be persistent because there is always someone out there better than you, more talented than you. So don't just be like, I'm good at this, that's enough. No, always look for the better. So thank you, everyone. Thank you so much.
Thank you. Also to your colleagues, see if anyone also would like to use the opportunity.
I would like to thank our coaches, Dr. Karim and Dr. Mohammed Shamsi. I would like to thank my colleagues that have always been supportive and all the opposing teams that we have been debating with. I would like to thank the hosts of the competitions that have gave us this nice opportunity to learn, especially like new skills that we should always be like open to being with and against at the same time, not just having our own point of view in it, especially when researching. And I would like to thank our university and our College of Law and the university and our other professors too that have been supportive. Thank you.
Well, thank you, everyone. For the second question in regards to our wrap-up of the Day 3 match, you have had several topics and areas of law that you have encountered during your studies, but also during the competition. Is there perhaps a particular area of law, country's legal system, or international organization, perhaps, that you would like to further explore, either as a student or later down as a professional? And this time starting with the team of United Arab Emirates University.
I think with the international law, it's always challenging with knowing the difference between what is customary law, what is soft law, what is legally binding, what is not. Because usually in domestic laws, it's always either mandatory or like legally binding, or it's just a rule that or a custom. However, in international, it's totally different. The system is way more challenging. I think that's one thing I found is more interesting when searching. It's knowing what is really actually binding and what is not. And I think it showed today in the match because most of our evidence that we have found are not legally binding or the rules. They're mostly soft laws. So I would like to investigate that more and learn about it and see really what's the difference. Thank you.
From my end, I think if I can make a small point as well, I think so far we've had our topics very international commercial law based as well, and it's super interesting. However, I'd like to learn more about international, maybe maritime law as well, something I find very interesting, international space law as well, maybe a bit more flashy topics as well, but something I'd like to see debated more because they're very topical as well, and something that, as a Maltese resident, I think that international maritime law is super important. And space law as well as the continent and beyond, it is super important, I think, to learn more about these topics. So definitely something I would like to see debated maybe in the future rounds.
For the other participants, Ms. Sayed, Ms. Almanea, Ms. Akilina.
If I could chime in, I'm personally very interested in emerging branches of international law. International law very much develops in response to, technological advancements, emerging different situations, even it being very much dependent and reflective of the geopolitical state of the world. So that is something that I do like to keep an eye out and stay updated on. And as Michael mentioned, also international space law, maritime law are very interesting. International human rights law, international humanitarian law are also very close to my heart. So I'm sure the upcoming rounds, if so, would also have a lot of interesting topics in store.
And Ms. Almanea or Ms. Gayet, if you would like to share.
I would like to say that I would like to research more and look more into today's topic because I honestly first time hear of this topic and I find it really important and really interesting, especially that we are facing this problem every day globally, and finding a solution to this issue will really help the world in a nice way. So I would like to look into it more deeply. Thank you.
And Ms. Almanea, if you would like to share.
I totally agree with the العنود and وجدان comments. Thank you.
Right. Thank you very much, everyone. It's been, honestly, on the side of organizing team, I just want to say it's been a pleasure and honor to see all the teams and your teams as well to progress from your first debates all the way to today. And we look forward to seeing where the wins take you further after this match. And of course, we look forward to seeing you at the mid-edition event. We're going to receive information about that soon via email. And I won't spoil too much, but you will be able to meet fellow group members, but also the other groups, and to interact with them. And with that, I pass now to Professor Lorange to wrap us up.
Yes, it was a very good match, and congratulations, free match now, and we hope, of course, there will be more. So as soon as we'll get, of course, the results, you will know, of course, the ranking for this group, and as well for the 8th of finals if you qualify. But I can tell you already that if you are from the group E, you get the 8th of final against group F, so the next group. So if you are among the two best teams of the group. So, and we encourage you indeed for networking. You will have the mid-edition event, so networking event at that time. But already from that match, so you can catch the opportunity if you wish to keep contact already between the two teams. So in any case, it was a pleasure, as said my colleague in this group. They were very interesting match and very, I would say, very interesting way as well for debating. So that was a pleasure, and I'm sure the judge as well will have a lot of pleasure, and we thank them as well for assisting this match. So many thanks again, and we keep in touch and wish you a great rest of the day, and don't hesitate to watch the last match of the group phase. There are some early next week as well. So thank you again, and we keep in touch. Thank you.
Well done.